It's really formative where John Marshall was born in Fauquier County because it's the frontier. This is British North America in 1755, and Fauquier County actually doesn't even exist until 1759, to give you a sense of just how frontier this was. And I think his whole life he is shaped by his experience growing up in the country. And you can see the Blue Ridge Mountains from here. You get a sense of the American frontier that shapes much of American history. And also, I think, just as a Virginian, he's a Virginian of a particular kind. He's not going to identify with the Tidewater aristocracy. He's going to identify with the sort of mid-level folks like his father was. And so I think the shaping of his life growing up in the open air, right, and being athletic and all these different things that that people will talk about for the rest of his life. The importance of the war in shaping his outlook for the rest of his life cannot be underestimated. He writes this letter at the urging of Joseph Story in 1827, so as a man in his 70s reflecting back on his life. And he says that he grew up in a time when love of the Union and resistance to Great Britain, or the claims of Great Britain, were the inseparable inmates of the same bosom. And so he says, "United we stand, divided we fall," was the maxim of every Orthodox American. Because you think about it, as a 19-year-old, this is a major decision that you're going to take up arms and become a traitor, which, if this fails, you will be hung. And to go in service of an idea, political liberty and self-government, to take up arms and then to fight. He sees action at Great Bridge, and then at Monmouth, Brandywine, Germantown. He sees, so part of it is just his courage, his leadership, but his political outlook. Right? He says it was there when he found himself in the army with brave men from different states, right, in a common cause deemed most precious, to then say that was where he started considering America as his country and Congress as his government. Now, if you think about the government at that time, the Congress was something of a failure, right? It was more like the United Nations, right? A sort of delegates from the individual states. It didn't have direct governing authority. So his politics later on in his constitutional outlook is the same as George Washington and Alexander Hamilton. They're the ones who are at Valley Forge, right? They're the ones who see the sufferings of the Army from the failures of a weak government that depends on the states. And so in a lot of different ways, just his personal experience, his constitutional outlook, his leadership. So it's also in the Army where has his first legal job. So he has no legal training by this time, but he's literate, of course, and smart as a whip. And so he's able to digest the laws of war and to administer military justice as a deputy judge advocate general. So I think in a lot of different ways you see his whole outlook coming together. And again, at a time when he's just entered into manhood. Right? He's got the rest of his life in front of him. He comes out of the Army, and that's how he builds up his legal practice, with his friends from the Army. John was a little bit of a disappointment when he shows up. So his father, Thomas Marshall, is living next to the Amblers. So Polly Ambler, or Mary Willis Ambler, but everyone called her Polly, is the second of four daughters of Jacqueline Ambler and then Rebecca Burrell Ambler. And this is just an interesting feature of this is Rebecca Burrell Ambler, so Polly's mom, had been proposed to in marriage by Thomas Jefferson. And she turned him down. And then marries Jacqueline Ambler. So they have four girls. They're living next door. And she and the other Ambler sisters are hearing about this strapping Captain Marshall who's writing letters from the front to his dad. And then John comes into town. There's this Christmas ball, and he is not the Greek god that they had figured. He's sort of awkward. He's tall. He's gangly. But Polly right there, so there had been competition for who was going to win this officer's heart, but she won by default because she decided that what did she say? She set her cap for John Marshall, and the two of them did have a bit of a romance. People speculate that one of the reasons that Marshall took time to study law at William and Mary in Williamsburg was because it was so close to Yorktown, where Polly was living. But they have a courtship over the course of a few years, and it ends in a really peculiar way. So by this point, the war has ended. John Marshall is practicing law in Fauquier County, but he's an assemblyman, he's a legislator, so he's going to Richmond, he's continuing the courtship there, and he proposes to her. And she says no. He leaves disappointed, and then one of her cousins intervenes and chases after John with a lock of Polly's hair. He comes back, she says yes, they get married in early 1783. And then they set up house in Richmond. So Marshall, his family, his whole life now is centered professionally in Richmond. Polly and John end up having 10 children. And they have children very early in their marriage. They have 2 children who are born. And then in a period of time, they lose 4 children, 2 miscarriages and 2 who died young. Those events caused Polly to spiral into some type of depression that she stayed in for the rest of her life. So she was very sensitive to noise. She was very cloistered in her existence. She would go out for church and the family would come in, but she was kind of cooped up in her room. And he would read to her. He was very tender and devoted. There's all sorts of stories about how, for example, he would come in the house and take off his shoes and walk around in slippers so as not to make too much noise, or if the neighbor's cow had wandered or some dog was barking, he'd go out and try and shush the animal for his wife. And so he's kind of, he's always a romantic, but he is caring for an emotionally frail wife. She's also really smart and has incredible judgment, which we only know about this because a year after she dies, so she dies in 1831, Christmas Day a year later, John Marshall writes essentially a lament for his wife, and he says, I never went wrong by following her advice. I sometimes strayed for lack of following it. And so you have this sense of an intelligent but frail person that Marshall cares for throughout his life. His relationship with George Washington really starts and is filtered through his father. So his father is a surveyor. He is in the House of Burgesses. And so his father, Thomas, is known to George Washington. And when John Marshall and Thomas Marshall are in the Army together, of course, Washington's the commander of the Army, and they may have had some interactions when John was a deputy judge advocate general, but it's really as a lawyer in Richmond, as an up-and-comer and someone who supports the Constitution from the very beginning, that Washington is aware we've got talent on this Federalist team here. And Washington tries to appoint John Marshall Attorney General. Marshall turns that down. He tries to recruit him for some other things, and he's ultimately successful. George Washington is ultimately successful in recruiting John Marshall to run for Congress in the late 1790s. And so whatever that relationship was, we know that they each had a high estimation of the other. Apart from his own father, whom he idolized, John Marshall looked up most to George Washington, the founding father. And then as he's in the Congress, Marshall is in some ways helping Adams carry on Washington's legacy, but Adams is dealing with a Federalist Party that is spiraling out of control. It's falling apart. John Marshall is on the floor of Congress in Philadelphia when word comes of General Washington's death, which was quite unexpected. And Congress adjourns for the day. The next day, Marshall still has the floor. So it's John Marshall who announces on the floor of Congress the formal address about George Washington's death. And it's John Marshall who utters the words, "First in war, first in peace, first in the hearts of his countrymen." And you'd say first in John Marshall's heart as well. Now those famous words, first in war, first in peace, first in the hearts of his countrymen, were actually authored by his fellow Virginian, Henry Lee. And Marshall would spend his life making sure that Lee got credit for those words. But it is Marshall who announced it. So really, from the beginning of his life, right, before he's born, right, Washington is in some way the presence in his family's life just through his father. Right, all the way through Washington's death, he becomes this formative figure. And then it's Marshall who writes the first formal biography of Washington, a 5-volume set of tomes really that tells the story of America through the story of General Washington. Some of it is really quite tedious. I haven't made it through all 5 volumes myself, but it is a military history as well as a constitutional history. And if you want to understand if you want to understand Washington's importance to Marshall, you really do need to read at least the 1st and 5th volumes of that biography, because the 5th volume is going to take you into the 1790s and into some of the formative fights in the early Republic. So Thomas Jefferson and John Marshall had a very complicated relationship. There was a sense of mutual respect in a way that maybe two tigers in a cage would have some mutual respect. They were opposites politically, really for their whole life. They are second cousins. So Thomas Jefferson and John Marshall are second cousins. They have some Randolph ancestry, but then again, so do many people in Virginia public life at this time. But if you think about some of their interactions and the way that would shape a public career for both of them, Thomas Jefferson is the governor of Virginia when Benedict Arnold in some ways sacks the city, right? Where he comes in as an invasion. You have invading forces now. John Marshall is there, and he's taking a break from the Continental Army, but a bunch of men go out to try and repel the British forces. Jefferson leaves town with the rest of the government. That's sort of one episode. Another episode, you have Jefferson as governor is the one who gives John Marshall his law license, but then he's going to use that law license, right, to entrench principles when he's Chief Justice that go against much of what Jefferson thinks the Constitution is about. So they are rivals really throughout their entire life. They have very different constitutional philosophies and a complicated background. And if we say, what do you attribute the real rift between Marshall and Jefferson? If you had to isolate one thing, it would probably be George Washington. So Jefferson writes this letter. It's a letter to Mazzei, and Mazzei is a foreigner. Jefferson, in this letter that eventually gets leaked and then published, Jefferson describes Washington as a Samson who has had his hair shorn by the harlot England. And you have a personal attack on the father of the country from Jefferson that will never heal. The rift from that kind of attack will never heal. And Marshall will write, the morals of the author of the letter to Mazzei cannot be pure. Right? He had contempt for Jefferson by that point, but he'd have to, in their mutual in their mutual duties, they had to measure that contempt. So again, another episode, you have Marshall as trial judge presiding over the treason trial of Aaron Burr, which is being directed by Jefferson from Washington. And again, you have this clash between the two of them that's mediated through this trial of the century. And you have an episode where Aaron Burr asks Marshall as trial judge to issue a subpoena to the President of the United States. This is an unsettled issue. Does he have the authority to do that? And Marshall decides that he does. He at least can issue the subpoena. Jefferson gets it, and he has to decide what to do. He never admits the authority of the court to issue the subpoena, but he voluntarily provides much of the information that was sought, and there was something of a detente there. So even though they had contempt for each other and had very different outlooks, they each realized that they had a role to play in shaping the country and in holding things together. So this relationship between John Marshall and Andrew Jackson forms over a long period of time. So we go all the way back. Andrew Jackson is a sort of up-and-comer, actually goes to Richmond for the Burr treason trial. So, and Jackson, of course, is a military hero. Marshall admires military heroes, but he is suspicious of Jackson and his form of populism. Right? He viewed Jackson in some ways as a demagogue, as untrustworthy in a lot of respects. And one of the things about Marshall's public life that is underappreciated is how much he tried to ensure that Native Americans were taken care of by the federal government. And so this is going to be a source of controversy or tension between Marshall and Jackson, because in the 20s, late 20s, early 30s, when Georgia in particular is moving the Cherokees out and the Trail of Tears, it's Georgia that's doing that, and it's the federal government that is supposed to be protecting Native Americans, but Andrew Jackson was in favor of the removal out west. And so they kind of circle around. There's a few cases, a few big cases that Marshall deals with on the rights of Native Americans, but two in particular kind of bring him into contact with Jackson. The first is a case brought by the Cherokee Nation against Georgia directly in the Supreme Court, and Marshall ultimately dismisses that case. The Marshall Court ultimately dismisses Cherokee Nation versus Georgia for lack of jurisdiction. But interestingly, Marshall, who is famously critical of the decision of his colleagues to dissent, in some ways he encourages dissent in this case, and he encourages the publication of Cherokee Nation versus Georgia. And we're not sure of the exact details, but in some ways lets it be known that perhaps there's another vehicle that you can use to bring federal authority to protect the Cherokee against Georgia. So the second case is Worcester versus Georgia, and this involves a missionary, Worcester, who was imprisoned by Georgia, and his case comes to the Supreme Court. And one of the issues that they need to decide is what is Georgia's authority here? And the Worcester was claiming the protection of federal law. Well, ultimately, Marshall vindicates the rights of the Cherokee, and they vindicates Worcester's rights, but that's just on paper. And there's this saying that's attributed to Jackson, which says, well, John Marshall has made his decision, now let him enforce it. Jackson probably never said that. It's not clear, but you get a sense from that about what their relationship was, because Marshall, as chief, is promoting policies through the law that are at war with the Jackson administration. So there's this great tension there. Now, before this can all come to a head, something else happens, and that is South Carolina's nullification of the tariff. So this was a very big issue for South Carolina. In its nullification of the tariff, we have the seeds of secession that will later tear the Union apart. But it's that nullification by South Carolina that then stiffens the spine of Andrew Jackson to bring the full force of the federal government against South Carolina and its states' rights philosophy and its threat to union. And it's at this point that Jackson and Marshall and the President and the Supreme Court of the United States are on the same page. This famous letter where Joseph Story says, "Now we're welcomed at the White House. Jackson is one of our closest friends, or we're the good guys now." And so even though they had very different philosophies, Marshall focusing on the law and on national union and on authority, whereas Jackson is focusing on popular support, right? A new kind of democracy. And what ultimately brings them together, though, is this threat to the union. And that's where they find they're both on the same page. And so you kind of go from a relationship of distrust to one of shoulder to shoulder standing to try and hold things together for the union. The winter at Valley Forge was horrible for the ill-supplied army. Marshall at this time was a lieutenant, and then he was raised to the rank of captain. He was also serving at this time as a deputy judge advocate general. So they didn't have supplies, they didn't have much food, and yet Marshall was the best-tempered man, his cabin mate would say. So here you are at Valley Forge suffering. As a leader, as an officer, your job is just to hold things together. Marshall, with his natural leadership and his "we're all in this together" attitude, does hold his unit together. There's descriptions of different athletic contests or him telling stories. And if you go look at the medical records of the various units, his had above average health. And so it's a horrible, trying experience, one in which Marshall appreciates firsthand in his bones the weakness of the government at the time and why you can't rely on the states. He's also witnessing George Washington as a leader holding together the army at Valley Forge. And so on a lot of different dimensions, right, on his politics, but also on his admiration for Washington, you also just see a natural leader too among his men. And think about this. This is the worst experience in your military career, and the worst experience of a military in American history, and your cabin mate is saying you were the best-tempered man and you never complained and you were bucking people up and telling stories and just holding people together, you get a sense of what kind of person Marshall was. When Marshall died in 1835, the Union and the prospects for the Union looked really gloomy. So for the last 10 years or so, he had been fearful that this great enterprise in self-government, where he was there from the creation, that it was going to fall apart. He said, "The Union has been sustained thus far by miracles. I'm not sure that it can last." And so he has a gloomy outlook. And he was right about that. And and the reason he was gloomy was because his great project was to preserve this union, right, through a philosophy of judicial nationalism, but it was preservative nationalism, one to hold the union together against the centrifugal forces of states' rights. That was his great project of maintenance and preservation. And he saw the seeds of disunion. He saw that slavery could tear apart the country. He saw that fights over Congress's power with respect to slavery and Congress's power with respect to legislation that would affect sections of the country differently. He saw it playing out, and he did not like what he saw. So John Marshall writes in Marbury versus Madison, right, is it emphatically the province and duty of the judiciary to say what the law is. In Marbury, what he's doing with those words is he is setting law apart from politics. Marbury was a case in which this gentleman Marbury had been given a public office of Justice of the Peace. His commission had never been delivered, and so he comes to the court seeking a writ of mandamus to have the commission delivered. This is a challenge for Marshall, because if he decides that the judiciary does have the power to order the executive to hand over this writ, he has to think about, how am I going to enforce that? And will they comply? And what if they say no? On the other hand, if he disclaims that authority on behalf of the court, you are letting the executive get away with violating the vested rights of Marbury. So what he does is he ends up giving a disquisition on the law that cast Jefferson as a lawbreaker, as someone who'd taken away something that Marbury was entitled to. But then he pivots from that to a discussion of the court's jurisdiction. And so now this is an escape hatch. He ultimately concludes that Marbury should not have brought his case in the Supreme Court's original jurisdiction, because the statute, the law that gave that original jurisdiction to the Supreme Court, was unconstitutional. And so when Marshall says it's emphatically the province of the judiciary to say what the law is, he is identifying the court's role to speak for the law as against politics. But also what he's doing, in the very next sentence, he says those who have to decide a case under law have to figure out what the law is. And so this is not a bold claim. It's not a surprising claim. He is laying the groundwork that everyone expected the judicial power to say what the law is, to be used in ways that include addressing the constitutionality of laws. So on the one hand, he's saying something profound that's separating law and politics, and on the other hand, he's making a fairly ordinary case for the power to set aside unconstitutional laws. The phrase, "we must never forget it is a constitution we are expounding," comes in the case of McCulloch versus Maryland. It's a somewhat abused phrase in the sense that people have used it over the course of American history to justify all sorts of things. So we must never forget it's a constitution we're expounding, so we can just kind of be loose with it. That's not what Marshall meant. In McCulloch, Marshall was addressing Congress's powers. And Congress's powers are set forth in Article 1, and they're listed, right? They're enumerated. Right? They're certain specific powers. And then he's identifying some implied powers. Now, when he says we must never forget it's a constitution we're expounding, what he's doing is drawing a contrast between a charter of government, the Constitution, and a detailed legal code. So a detailed legal code, you would expect all sorts of specifics and lots and lots of minute specifications of things. The Constitution, by contrast, when you're expounding a constitution, it is a charter for government, and you're empowering the government. And so what he's saying is you shouldn't expect every little detail. And so when you're considering, does Congress have the power to create a banking corporation? The fact that the Constitution doesn't say, oh, and by the way, you can create banks or you can incorporate entities. Marshall says that's okay, because what Congress has is the power to achieve certain ends, but there are implied powers to use different means towards those ends. So let me just give you the short version, right? When Marshall says we must never forget it's a constitution we're expounding, he's contrasting that, a charter of government, to be read generously in its grants of power, with a detailed legal code that you'd expect lots of specifications in addressing narrow issues. Marshall was not a living constitutionalist. If you think about the core of his mission as a judge, but also as a statesman in other things, it's preservative, right? He views the Constitution as an achievement, and he's constantly going to be looking backwards to that achievement, that grant of power, that creation of a government that can act directly on the people. And so if it's a living Constitution, you can't do that same thing. You can't look backwards and say, this was done, this deed was done, and here are the consequences. Because by its nature, instead, it will drift according to the times. The idea, another reason to know for sure that Marshall wasn't a living constitutionalist is nobody was. The idea of a living constitution really didn't emerge until decades after Marshall dies in 1835. It takes a little while at the outset to figure out just what kind of document this is, but by the 1790s, the idea that the Constitution was fixed in place was itself the pivot around which constitutional debate happened. The idea that it was a fixed constitution was agreed upon. Everyone disagreed on exactly what was fixed. And so Marshall was not a living constitutionalist. Nobody was then. Where Marshall is sometimes described as a living constitutionalist is because of another phrase from McCulloch versus Maryland, when he says it's intended to endure for ages to come, this government that's created by the Constitution, to be adapted to the various crises of human affairs. Right? And so you can see, if you're describing, say, this is supposed to endure and to be adapted. But what he's talking about there is the government and the government's powers, not the Constitution itself. It's precisely because those powers are fixed at the outset that they're to be given a generous interpretation or a not overly narrow interpretation. The idea that he was adopting living constitutionalism in McCulloch versus Maryland really does not emerge until a century later. The thing about Marshall is that he is such a founding figure, right? He's the founding father of American constitutional law. And so when you're in constitutional debates, you want Marshall on your side. So it's not surprising to find people throughout American history, particularly jurists, projecting backward their favorite ideas about the Constitution and the government's powers, projecting them back onto Marshall. This happens with living constitutionalism. This happens in construing Congress's power to regulate commerce, right? To read some of these decisions from, say, the late 1930s, early 1940s, you would think that Marshall was, you could draw a straight line from Marshall to the administrative state. It's anachronistic, but it's common enough, and that's because Marshall is so foundational. The Revolutionary War, which was so formative for Marshall, was really just the opening act, right, of the creation of a new government. And during the years that pass, about a dozen years, right, between when he's in the Continental Army and then when he's at the Virginia Ratification Convention, Marshall sees the weakness of relying on the states. He sees the trouble that comes from state legislatures as well. And he sees the danger of understanding this new government as a creature of the states. This was a very popular theory. It's known as compact theory, the idea that the Constitution came from the states as a contract. Marshall's view was very different. Marshall believed that the Constitution came from the people of the United States. So if you think about the preamble, we the people of the United States, in order to form a more perfect union. Those phrases give you a key to Marshall's jurisprudence because it's telling you that the Constitution comes from the people of the United States, of a nation, not people of a state, and that the first object is to form a more perfect union. The union pre-exists the Constitution. You have a nation, and then the Constitution is there to provide a government for that. And this is crucial because the nature of the Constitution, was it a compact among the states or did it proceed from the people? That was not settled in American law and American history. Marshall tried to settle that in some ways as best he could in McCulloch versus Maryland when he talks about the nature of the Union and how the government proceeds from the people. But it's not until what we might call the case of Grant versus Lee, in the Civil War, or the war between the states, depending right? How you think of the nature of the Union. It's not until the case of Grant versus Lee that the nature of the Union and of the Constitution is settled, and not in a court of law, but on battlefields. And yet, Marshall's conviction that this was a government from the people and not from the states was a powerful strand that carried forward the nation from Washington, right? First in war, first in peace, right? And when are we most at one as a nation? At war, right? That's how they were first together. And then you go to Abraham Lincoln. Now, Abraham Lincoln is not going to have, he's not going to be quoting John Marshall. He's not going to be looking to the Supreme Court for guidance, because Roger Taney, the next Chief Justice, is the villain for Lincoln. And it's his decision in Dred Scott, rejecting Congress's power to control slavery in the territories, that precipitates the breakup of the Union. But what Lincoln does imbibe is a constitutionalism and an understanding of the Constitution that emanates from Marshall, that's transmitted through Daniel Webster, Henry Clay, John Quincy Adams, the people who form Abraham Lincoln's constitutional outlook, so that as a young postmaster, when he's reading Supreme Court decisions and when he's forming his outlook, you have this idea that the government is of the people, that is picked up, that is formulated classically by Marshall in McCulloch versus Maryland. He says this is a government of the people. It is formed for their benefit and is to be administered for them. Well, it's Daniel Webster then, when South Carolina is threatening to pull out, and when Webster is debating Hayne on the floor of the Senate, and in his second reply to Hayne, he picks up this language from McCulloch versus Maryland. And it is that Senate speech that is then formative for Abraham Lincoln, so that in the midst of the Civil War, when Lincoln gives his brief address at Gettysburg, when he concludes that there shall be a new birth of freedom, and that government of the people, by the people, for the people, shall not perish from this earth. It is the voice of Marshall carried through Webster that is putting those words in Abraham Lincoln's mouth. John Marshall's main objective as Chief Justice was to have the judiciary recognized as a co-equal branch of government and as a court of law, and to separate out law from politics, and to have the voice for the Constitution as the supreme law. The judiciary would be very different if Marshall had not served as Chief Justice, and we know this because of the transformation that took place during those 34 years that he was Chief Justice. He was the Secretary of State who received John Jay's rejection of the job, and John Jay, the first Chief Justice, had said, when I left the bench, I was convinced that it would never, the national judiciary, not just the Supreme Court, Jay says, I was convinced that the national judiciary would never have the energy, weight, or dignity befitting tribunals of a nation. That is 1801. Fast forward to 1835. The Supreme Court has now faced down presidents. It's overruled acts of Congress. It is operating at a very high level. It has energy, it has authority, and it's Marshall's leadership that brought the court, and also the national judiciary more generally, to that very, very different spot. John Marshall would be surprised that the Supreme Court of the United States is as powerful as it is, and the other branches of government defer in some ways, right? He was struggling constantly to hold things together, to assert the court's authority. Now the problem is the opposite. You have a court that is not restrained, that has made some major interventions into American public life because of the essentially abdication of others with authority. So the idea, for example, that state attorneys general would be running to the Supreme Court for protection against federal legislation would be really quite foreign to him, right? Because he was attempting to, in some ways, wrestle the states to the ground to have jurisdiction over them and to bring them in. Now the tables are turned, where you have the states that are coming to the court to try and get protection from this federal government. And so that would be a little topsy-turvy, I think, in his outlook. John Marshall had insight into the judicial power that was full of practical wisdom that judges today can look to. It's a little dangerous to try a WWJMD. What would John Marshall do? So much has changed. We have the Reconstruction Amendments, 13th, 14th, and 15th Amendments. We have a national income tax. The Senate is different. So a lot has changed. But for the basics of the separation of powers, right, Congress's job to make the laws, the president's job to execute them, and the judiciary's job to decide according to law and resolve disputes, those are still constants, and anyone who wants to understand the nature as well as the limits of judicial power should study Marshall carefully.